everyone. Good morning, good afternoon, and welcome to this special edition of Arcview Access called Litigating Messy Cannabis Contracts with our partner Zuber Lawler, who will unpack some recent cannabis litigation cases, and we get to learn about what to look out for when we're entering into these cannabis contracts. And when we mean cannabis contracts, we're talking about M&A deals, investor funding rounds, and even product and business contracts as well. So full disclosure, I am not a lawyer, but to help me prepare for this event, I thought I'd do a little Google searching and just see what's happening right now in the world of cannabis litigation. Here's what I found in literally 5 minutes of search: restructuring support agreements, class action lawsuits, product liability claims, patent infringement, injunctive relief, receivership, antitrust laws, racketeering, fraud, failure to pay, and libel. So this is just a short list of cases happening right now in our industry, and unfortunately, there will be more. So I'm not here to scare you. We're here to figure out what we can do to maybe avoid this, or if it's not avoidable, what we can do to win it. And especially when just a few years ago, many of us, myself included, put aside some of our legal best practices and even our gut feelings when it came to investing in cannabis businesses. After all, it is still federally illegal. There's a massive disproportionate amount of taxation for cannabis businesses. We have illegal market competition. We have countless expenses and most often an insufficient legal and compliance budget in the companies in which we invest in. So after the double dips that we experienced in the public markets, and now perhaps a renewed traction in our regulatory process, we may see more of this sort of shake out. Some of those early contracts that you or your company signed in its startup heydays could potentially be the focus of a high-stakes dispute. So, folks, this program is for you. You need to know your options. You need a creative strategy fashioned by attorneys who have seen and litigated the messiest cannabis contracts of yesterday. And they're also here to help us create these solid contracts for the cannabis companies of today. So my first guest today is Jeff Zuber, and he is the founder of Zuber Lawler, who was recently named Cannabis Law Firm of the Year by Marijuana Venture Magazine. Jeff focuses on high-stakes intellectual property, regulatory, and commercial litigation. He does this work for Fortune 500 companies and funds, as well as leading cannabis companies. He's had extreme success representing clients in hotly contested corporate partnership disputes in the cannabis industry going back now over 14 years. And he just recently won a $65 million award in an arbitration case over a cannabis distribution contract relating to the Weekend Box. And this, by the way, included punitive damages and attorney's fees. He is increasingly focused on the emerging psychedelics industry as well, so I want you guys to stay tuned for another show on that one. Joining Jeff is David Bright, who has significant experience in complex commercial, shareholder, and contract disputes. David has also experience with FCPA issues, anti-corruption compliance, and internal investigation. He often works in relation to cannabis and has successfully litigated matters for some of the biggest brands in the cannabis industry. So before I bring these fine gentlemen on stage, I'd like to remind everyone to please use that Q&A button at the bottom of your screen to ask your questions. We will have time for that at the end of their presentation, so I want you to make sure you put those in there so we can prioritize them. And if you'd like to get in touch with anyone here at Arcview or the Zuber team, please go ahead and put your contact information in the chat so that we can also reach out to you after the show. So welcome, Jeff and David, and thank you for joining us today.
Hello, everyone.
Good afternoon, everyone, and thank you, Kim, for that kind introduction. And I'd like to thank everyone for taking the time to join us for today's presentation. Our presentation today is broken into several short modules, but before I get into those modules, I'd like to talk briefly about the goal for today's presentation. Generally speaking, the goal of today's presentation is to give everyone a survey course or a broad overview of sorts of common legal problems that arise between business partners in the cannabis space. Now, business relationships are typically grounded in contracts. It doesn't matter if you're investing in a cannabis company, entering into an operating agreement, or engaging in an M&A. Contracts are ultimately what define the rights, duties, and obligations of each respective party. And in many ways, contracts, therefore, set the tone of a business relationship because contracts frequently dictate which party has more leverage over the other. And this often determines the power dynamic that governs the relationship between the two contracting parties on a broader level. Now, Jeff and I don't draft contracts. We have another team of attorneys at Zuber Lawler, transactional attorneys, who manage the drafting of contracts. Instead, Jeff and I are litigators, which means we are only able to get involved in these cases after the business relationships have started to fail, which is almost certainly after a contract has already been inked. But with decades of commercial litigation collectively under our wings, especially in the cannabis space, Jeff and I are particularly well equipped to talk about what are the most common issues we see arise between cannabis partners, and more specifically, identifying the role that contracts play in those disputes, as it's frequently a poorly drafted contract that leads to a dispute, and it's also frequently the case that the strength or weakness of a contract can greatly enhance or restrict the client's ability to effectively resolve a dispute. To that end, today's presentation is broken into 5 short modules. First, we'll talk about contract formation. What are the things to consider, generally speaking, when drafting a contract? Next, we'll talk about contract provisions that Jeff and I see most frequently lead to disputes in the cannabis space. After that, we'll talk about some things to consider when litigating contracts, and then we'll talk about cannabis-specific issues that impact litigating contracts in the cannabis space. And we'll end by spending some time discussing cases that Jeff and I have litigated that showcase some of the issues we discussed in the presentation and demonstrate how they play out in the real world. Those case studies include a failed M&A, a requirements contract that went sour, and a couple of other choice cases, including the case that Zuber Lawler recently litigated that resulted in the award of $65 million in damages. Now, the first module briefly discusses contract formation. Now, in an ideal scenario, you'll want to have a team of professionals working with you to advise in the formation of a contract. In the cannabis space, industry experts are especially important because they help point you in the direction of trusted connections and referrals to ensure that your business partner has been vetted and is a known quantity. This is particularly important in the cannabis space as it's a relatively new industry with a slew of unproven entities. Regulatory consultants are also a requirement given the complex regulatory schemes that change not only on a state-by-state basis, but on a local jurisdictional basis too. And transactional attorneys, specifically with experience in the cannabis industry, to look out for the type of provisions that commonly lead to these disputes in order to avoid them forever arising. Now, that's the optimum solution. But there's overarching tensions and trade-offs that often prevent you from adhering to that optimum solution. And these tensions and trade-offs usually include the need for speed. You want to get a contract done as quickly as possible. These tensions and trade-offs frequently include cost savings. You don't want to spend the money on an attorney, or you don't want to spend money on a lost opportunity by delaying the finalization of a contract. Another concern that pops up is that you don't want to overcomplicate matters. Sometimes bringing in a team that includes regulatory consultants and transactional attorneys can often be thought to scare away your business partner. The trade-off, however, by following those 3 different trade-offs is that you're going to be losing out on completeness. You're going to be losing out on the number of provisions that are included in there that adequately describe the duties and obligations of each party to one another. You're also going to be losing out on someone who's able to look out for adequate protections and ensure that they're included in the contract so that if everything goes sour, there's something in there that allows you an out. More importantly, you're going to have an advocate who doesn't compromise on your position and your demands. Now, understanding that some people will be able to go with an optimum team that includes industry experts, regulatory consultants, and transactional attorneys, while others are going to have to forego that optimum solution and do it themselves or do it in some sort of abbreviated or pared down way, there are still some common goals and considerations that go into contract formation. Generally speaking, when you're drafting a contract, The primary goal is obviously laying out what the obligations of each party is. But in addition to that, you also want to be able to ensure that the provisions ensure accountability and ensure that each party adheres to the contract, thereby including penalties to make sure the obligations are fulfilled. You also want to create mutually reinforcing incentives, such that your partner is incentivized to support your goals just as you're incentivized to support theirs. You want to be able to avoid some key issues, such as theft of confidential information, trade secrets, assets, and/or key people. You want to be able to create a reasonable out with a good termination provision, and you want to be able to minimize the fallout from a failed relationship. Now, with that context, Jeff will address what are some of the more common provisions that lead to disputes among business partners in the cannabis space.
Thanks, David. Good morning, everyone. Yes, I'll be talking about some of the more problematic provisions that we've dealt with and things that you should be considering when you're entering into these contracts. One thing I want to point out is that David and I will be talking a lot about things that happened before the litigation, but I assure you these are things that we wished that the clients and sometimes their attorneys had considered before there was a dispute amongst the parties. Thinking about these things beforehand, talking to an attorney and people, consultants familiar with the regulatory landscape is crucial to avoid these disputes in the first place, or if you're in them, to be well positioned. And the first topic I want to talk about is inadequate termination provisions. And this is something that is easily missed. It's very important to put easy out termination provisions, 3-month assessments with rolling renewals, for example, inclusion of achievement hurdles, stating goals of the contract with both parties, for example, frustration of purpose, and accountability provisions in case of termination. And again, the concern here is that these provisions, these types of termination provisions often get short shrift in our experience. The parties are generally so optimistic when they're forming the relationship and during the honeymoon period that it's not as big of a concern. The fact that the falling out isn't looked into as much as some of the other provisions. And that's why we're bringing it up first. But working these terms out before there's a dispute can make resolving them so easier, and in fact can help make sure that a dispute isn't escalated to the point of litigation in the first place. When you work these things out, the parties are able to exit the dance floor without undue escalation. Another thing you have to think about, which is very similar in theme, is damages provisions. Expectancy damages versus liquidated damages versus no damages. What we're talking about here is normally when there's a breach of a contract, in general, the remedy is that the non-breaching party will get what they should have gotten had the contract been fully performed. That's called your expectation damages. But when the expectation damages are very hard to ascertain, sometimes this can be because the business is a startup, it's very speculative. Sometimes it's because it has to do with reputation of a business, something that's very hard to quantify. What you'll do, because expectation damages are hard to find, but you know that the harm is there, is to put in a liquidated damages provision. And even though the damages are hard to quantify, they have to have some sort of foreseeability. They have to have some rational relationship to the harm that's being done. And to put these in to begin with will help a lot in terms of resolving these things in the end, or again, putting you in a good position should it become litigated. The limitation on liability is also very important and something to consider. Sometimes you don't want to be on the hook for damages for loss of business. Again, especially when you think the other side is very litigious, very aggressive, likely to inflate these damages and increase the liability such to the point that you don't want to be held liable, but also is going to prevent some sort of rational settlement, especially if you have very aggressive litigation counsel that are pushing for a very, very big reward. Having these things worked out ahead of time can resolve, and again, not only resolving it better, but avoiding the conflict in the first place. One of the things that, and a lot of people have these, the confidential trade secret provisions to protect your confidential information. But very often what we see is that they're not very well suited to the situation, or they don't have a lot of teeth, a lot of things that you want to see when you're trying to enforce these things. So it's important to have an initial NDA. It's also good if you know that there are going to be some vendors that have access to these secrets that you're licensing out or allowing a contractual partner to see, to have a form NDA to begin with, so that anyone who sees these secrets, these ideas, and they can sign on to the NDA as well, or they don't get to see them, and that can help. Another thing you can do is make sure, and this goes beyond the actual contract itself, is making sure that you compartmentalize information where it's appropriate. This may seem unrelated to the litigation, but I can tell you that when you're litigating, one of the definitions of trade secrets is that you took reasonable precautions to protect them. So it's very important that you think about things and you talk to a trade secret lawyer beforehand, so that you can put these things in the contract to make sure that your secrets are protected. Another thing is sometimes you see provisions that are too broad or too specific. And you want to have kind of both. You want to have the overarching protection of trade secrets to the extent the law will allow. And if you have very specific things that you know you want to protect, you want to put that in there as well. And as we just discussed, with regard to liquidated damages, if some of your trade secrets, it would be hard to quantify the amount of damages done from the disclosure, you may want to consider a liquidated damages provision to give this teeth as well. So some of these concepts that we're going to be talking about certainly are related. Another big issue that you want to think about is non-competition and non-solicitation agreements. And although the law varies from state to state, they're generally disfavored provisions, and especially so in the state of California. California Business and Professions Code 16600 prohibits agreements that are in restraint of trade. And there are two very notable exceptions, one being the sale of a business, sale of equity, and the other being trade secrets. You can prevent people from competing if they are using trade secrets that they misappropriated. So again, you want to make sure that you have that provision very well drafted, and that you've talked to an attorney about doing the other things you need to do to protect them. Another issue is the constraint of a person versus an entity, and this has come up in a recent case with us. And it's not uncommon where an entity is restrained from competing, but key principals who lead the entity aren't necessarily named as individuals in the non-compete. And in these situations can be very difficult to enforce. These provisions are enforced by the courts very strictly against the drafter. So you want to make sure that you give a lot of thought, and that if a lot of people are going to have access to them, that they sign on to NDAs, and if they are principals who are certainly going to be dealing with this information a lot, that they're named individually and sign off individually on these agreements. It will make it much easier to enforce. Another thing is that you want it drafted well. You don't want it to be too broad and to lack territorial limitations. Now, very often courts will imply some of these terms, including territories, if you don't have them in there. But I can tell you, when you're enforcing these things, you want them to look like they're supposed to look. You will have an easier time enforcing them and convincing the court that these are reasonable restrictions if they're well thought out and well drafted. You don't want to look sloppy. You don't want to be overbroad. You don't want to have to be asking the court to imply provisions that should have been in there in the draft to begin with. Also, you don't want it to be too narrow so that they're not going to be effective. So a lot of thought has to be put into all of these provisions. You also want a merger clause in there generally to make sure that you can minimize the litigious nature of some parties to try and do anything they can to get out of these provisions. Now, even a merger clause is imperfect, especially in California. If there is any ambiguity or vagueness about these clauses, courts will often allow parole evidence, outside evidence, to help it interpret what these terms mean. And so what they're doing is not looking at other evidence to see what the deal is, but to use that evidence outside the contract to interpret the terms and figure out what the parties intended. And I can tell you this, that lawyers are very, very good at finding ambiguity where normal, rational, reasonable people will not see any. We're paid to do it, and we're very good at it. So you want to make sure that you have these merger clauses, but that also when you're conferring with the other side in your emails, that you're careful. Because these emails are going to be exhibits A, B, and C against you when you're trying to enforce those contractual terms. One final specific provision that goes into these contracts that often are very important when we're litigating them, but often get short shrift in determining whether they should be there, is an attorney's fees provision. What we're talking about is if you end up litigating these things, very often there's a provision that says the prevailing party in that litigation or arbitration is entitled to its costs, including reasonable attorney's fees. The things you want to consider is, and it seems like a very innocent clause put in there without a lot of fanfare, but in modest disputes, which are important to, especially to startup companies, they can be driven by these attorney's fees provisions, especially disputes under $1 million in total. The lower you get, the more these attorney's fees provisions will drive the litigation, because parties, even if they think they've got a strong case, if they know that they can't afford to lose, it's going to affect whether or not they want to file. When you're considering whether to put an attorney's fees provision in your contract, there are at least two key factors you have to think about. One is who is more likely to breach this contract. I can tell you that if I'm concerned that my client is probably more likely than the other party to breach the contract, especially where almost all the performance under the contract is by my client, the other side just has to pay and they paid up front, I'm not inclined to include an attorney's fees provision. I don't want my client to have to deal with that. Another thing you want to consider is whether or not the adversary can even pay off on a judgment. If they can't pay off an attorney's fees award, these things can almost effectively be a one-way attorney's fees provision, because if your client wins, they're going to end up with an award, including an attorney's fees provision that the other side can't pay. Now, if the other side is on the hook as an individual, they may be inclined to pay anyway. There are other factors that influence this, but ultimately, these are two of the big factors we look at in terms of whether to include this. Do not include the attorney's fees provision as a matter of course. Figure out what the relative bargaining position is amongst the parties and talk with your attorney about it to make sure it's the right thing for the contract.
So Jeff talked about contract provisions that we commonly see in any and all cannabis disputes we hit on. What I'd like to talk about now are contract provisions that we frequently see in M&A disputes. And the number one contract provision that usually leads to a dispute is the earn-out provision. The most simple part of this dispute is simply a failure to adequately define what EBITDA is and or what the earn-out hurdle is, and or failure to adequately identify what are the agreed upon accounting principles that will be used to calculate the EBITDA and or financial hurdle that may be in line. One of the broader, more complicated issues with an earn-out that we see pop up is a misalignment of incentives. And this is very frequent in M&A disputes because quite often you're going to have two separate management teams, obviously the acquirer and the entity that's being purchased. And in some cases, you're going to have individuals on both of those teams staying on with the final entity. And in a situation like that, you sometimes have an alignment of incentives. You may have the new entity, the purchase entity, still being run by the old management team. And therefore, you have an alignment that the old management team, which is invested in the company doing well because they're invested in earning the earn-out by hitting certain financial targets, there's an alignment of all incentives. However, when you bring in a new management team, which is also very common when a seller wants to essentially take over a distressed asset that has not been performing at market, they want to bring in a brand new management team, get rid of the old team, and therefore you're going to have a new management in place that's going to be steering that new entity. And that new management now does not have an incentive to hit those earn-out hurdles or those EBITDA hurdles. And as a result, there's a misalignment of incentives such that they can slow play earnings such that EBITDA hurdles are delayed in being hit, so that instead of being hit within year 1, 2, and 3, a company is not brought to a positive EBITDA stage until years 4, 5, and 6. And instead, in years 1, 2, and 3, the company engages in a lot of purchasing or asset acquisition that ensures that the EBITDA hurdles are actually not satisfied, and therefore no earnout is paid out. Being able to create provisions that align those incentives of the buyer and the seller is probably the most important thing to do in order to avoid a dispute over the earnout. Probably the second most important thing to do with regard to an earnout is to include provisions that prevent from self-dealing. One of the more common things we see happen in the case of an M&A when there's an earnout provision in place is that there's no actual mismanagement of the company as much as there is a poaching of the assets for which the company was highly valued. And in a scenario like this, you have a buyer who comes in, purchases a company, manages the company adequately, so there's no claim you can bring that there's been any mismanagement or intentional missing of any EBITDA or other financial hurdle. But instead, what they do is they use the assets of the company and either sell them to their own other entities and or use those assets to be shared among other of the company's affiliate entities without providing any sort of adequate revenue stream to compensate for use of those assets. And that sort of self-dealing is probably one of the most common forms of contractual disputes that arise in earnouts. And it's primarily addressed by ensuring that there's provisions in there that identify the core assets of the company and also describe how it is those assets can be used by any of the purchasers, affiliates, subsidiaries, or parent entities, and or how valuations of the assets should be done in the case that those assets are going to be later on sold. A second issue with regard to M&A disputes that frequently pops up are in regard to indemnity bonds. And the simple issue here is that indemnity bonds are frequently quite low in the amount that is allocated because with an M&A situation, you've got two parties who are working together collaboratively, ideally for the same goal. And therefore, there's a lot of inherent trust in that sort of relationship. And that trust leads to people underestimating the intentions of the other parties and or the bad faith or bad intentions of the other parties. And that usually leads to a underfunding of the indemnity bonds. The third broad issue we see in M&A disputes is around breaches of representations, warranties, covenants, and guarantees. This relates back to what Jeff was talking about, the incorporation doctrine or the entire agreement principle. Essentially, this idea that most agreements, and almost certainly every M&A agreement, is going to include a provision that says that the M&A agreement includes any and all representations and agreements between the parties. Now, in an M&A, again, there's this great deal of trust and collaboration between the parties to get the deal done. And in that sort of relationship, you have a number of really important representations that are frequently stated and shared amongst the parties that are not included in the contract. And that is frequently what will lead to a dispute over what someone has promised, but what someone has failed to include as a promise in the actual M&A contract itself. That relates to the failure to define material representations and identify which are the ones that each party is relying on in order to enter into the contract. Another issue is post-closure discovery. A buyer will frequently buy a company, and it's only after they've purchased the company that the real facts will come out. And in the short couple of months in which the buyer has the asset under his or her total control, that's when they're able to get access to employees, to records, to documents, to financials that otherwise have not been made available. And so it's often quite important to include some sort of provision that allows an easy out or a clawback after a 3-month post-closure discovery, and or that prohibits any sort of post-closure discovery from leading to any sort of claim against the buyer or seller. And the next issue that pops up is that when you have, especially in the case of a smaller M&A, individuals who are negotiating on a one-to-one basis, and you're having an individual who's making a lot of reps and warranties, failure to include some sort of personal guarantee that ties them to the promises that they're making that may not otherwise make it into the representations and warranties in the M&A agreement. The next set of contractual provisions we see issues with are in shareholder and financing disputes. The primary issue in this case are really simple. easily avoidable issues, and they largely revolve around the failure to adequately define the shareholder or investor's rights. Anti-dilution provisions are probably the number one issue we see in this space. Failure to adequately define whether or not the shares or equity that's being granted is subject to dilution. If it is subject to dilution, what are the rules by which it's subject to dilution? A failure to adequately describe, identify, and really cordon off what are the voting rights, participation rights, and what are the rights in the case of liquidation preference. Similarly, a failure to either identify and or think holistically about what the transfer restrictions should properly be. In this area, what we frequently see is a copy and paste job done, where people are relying on transfer restrictions that are a one-size-fits-all approach, and that's not necessarily the case for every party. And so transfer restrictions frequently should be considered a little bit more unique and tailored towards individual parties and not a one-size-fits-all. When you take that one-size-fits-all, that often leads to not necessarily litigation disputes, but a renegotiation of those rights at a later date when the parties realize that has become an issue. Another area of dispute that pops up is valuations. Valuations, a failure to essentially identify a mutually agreed upon method for calculating the valuation, both at the pre and post-transaction value. It's important, if you can, in a shareholder financing agreement, to be able to identify what was the valuation or basis for valuation at the time that the investment was made, but also how it is the parties are going to be valuing at the time, for example, that a convertible note is going to convert. If there is a dispute amongst the valuation, parties can litigate and fight it out. Alternatively, you can include provisions that account for that possibility later on and actually prescribe a specific way to do a valuation so as to avoid litigation that is unnecessarily and costly for both parties down the line. Another very common issue we see, especially in the cannabis space, is the use of restricted stock purchase agreements in exchange for services. In this situation, you have a cannabis provider who's working with a slew of new service partners. And in order to be able to secure their business, they've not only simply entered into a services contract, but they've offered a stake in their own business moving forward. The key issue we see here is that there's a lack of cross-default provisions. And what we mean by this is it's okay to give service providers an equity stake in your company, but there has to be some forethought as to what will happen if they stop providing services or they do a breach of the service contract. There has to be some sort of clawback provision that allows for you to reclaim that equity in that sort of situation. And the other area where we see issues specifically is with convertible notes. One of the primary issues is a lack of securitization or a failure to get some sort of personal guarantee. We've also seen disputes with regard to the failure to secure an automatic conversion. The vast majority of convertible notes will convert at a very specific time and will be converted without the investor's option. However, we have seen some copy and paste sort of contracts that have been included in equity agreements between business partners where the investor retains the option as to whether or not to convert. And in such a situation, that's not really quite a convertible note as much as it's a loan and should be considered a loan by the company unless and until the investor opts to convert. Another issue we see with convertible notes is also the failure to adequately identify the trigger events for an actual conversion. Now, together, these provisions that Jeff and I have talked about are the most likely to lead to disputes between business partners, but I'll hand over now to Jeff to discuss what happens after the dispute has risen and you're now considering what your litigation options are.
Thank you, David. And these are some initial considerations I'm going to be going over, and I can see we're running short on time, so I'm going to pick it up a little bit here. One of the key things to consider is the goals of the litigation. And money, at least in theory, money's the easy thing. Money damages. Trying to figure out the amount, lawyers will squabble over that a lot. But it's usually easier to handle than equitable relief. Trying to get the party to stop doing something or to do something it's supposed to be doing, which is even more difficult. Sometimes a motion for early injunctive relief, while expensive, can dictate the course of the entire litigation. Sometimes if people don't get that early relief, they don't feel like the case is worth pursuing. And that happened to us in one very big important case that we dealt with that we won't be discussing today. But it is important to understand how to get the appropriate leverage, whether you're entitled to this injunctive relief, and whether it's worth financing the application to get it early on. It's one of the most important decisions you can make with your attorney in determining whether or not to actually file a litigation or make an arbitration demand. Obviously, the likelihood of prevailing is always a key concern. If there's a strong paper trail, we, your lawyers, will be able to make some strong assumptions regarding your chances of success. However, many litigations are very messy with a lot of moving parts. In fact, as I discussed before, the more uncertain it is, the more likely it's going to be litigated. Contracts that are clear and seemingly unambiguous at the time of the drafting sometimes don't seem so clear in contemplation of how the parties actually behaved in performing that contract. So making an early determination with counsel after the key evidence has been reviewed is crucial to determining whether or not to take the plunge and initiate litigation. The next three concerns kind of go hand in hand, so I'm going to talk about them together. That's the timing concerns, cost of litigation, and the opportunity cost. And this is something that you, as a business owner, have to discuss with your attorney in terms of balancing the value of the litigation as an asset versus the other things you can be doing with your money. And for a lot of you startups, this is going to be the crucial driving force of whether or not you decide to litigate. It can take over a year to get to trial. It usually does to actually get to a trial. Arbitrations can be quicker, but they're not necessarily quicker. Arbitrators have a little bit more ability to and are expected to put a tighter leash on the attorneys in terms of how broad discovery is going to be. But the bigger and more complex the case, in general, the longer it's going to take. So you have to think about what your business goals are, and can you get accomplished while nursing this litigation, which can grow. They're like children. They can just grow out of control. And what you thought was a very simple case, a very hostile, aggressive opposing party, especially a party with deep pockets, has turned it into something else. So you have to think whether or not you can deal with this cost. You have to anticipate those legal bills coming in and those invoices. And is this case going to be as important to you after you've seen 6 to 12 months of invoices from your attorneys? You need to work out a good budget. When there's changes, you have to talk with your attorney to see whether or not this can continue, whether or not your litigation tactics have to change. And also, in terms of the lost business opportunity, you have to think, what else can your employees be doing? Chances are, especially if you're a startup, you're on a tight budget. Your employees are working very hard. They'll be distracted with gathering documents, gathering other evidence, making witness statements, preparing for depositions. All of these things are taking them away from these things that they were born to do and love to do, which is work on your business. With regard to collectability and enforcement, this is a key issue, both when you're on the plaintiff side and defendant side. When it's over, will the adversary be able to pay out on a judgment? That also factors into how much you're willing to spend on this asset, this litigation. If your company is the defendant, and if there's a significant chance of liability, will you be able to wind this company down and move on? Are there individuals that made guarantees? Are there claims of individual liability that may survive the winding down of the business? Have you been observing corporate formalities along the way so that individuals won't be on the hook? These are some things you have to look at in determining what you need to do to either pursue the litigation or, in turn, to make sure that it doesn't happen and to resolve it and settle it before it escalates. Okay. Moving on to the forms of litigation, the first thing is negotiation, and this is important. And again, even if you don't retain an attorney, most attorneys, including us, if you call us up and you discuss it, first of all, that initial call is confidential. And we do get the impression that a lot of people are hesitant to call attorneys. They think the meter might be running right away. They're concerned about, sometimes people are concerned about hearing bad news and don't want to hear it. They want to work it out before it gets to that. I can tell you when you call an attorney, it's confidential, even if you don't engage them. If you talk talk to them in the context of getting counsel, that is protected as well. Otherwise, people couldn't call attorneys. And most attorneys like us will devote a significant amount of time to listening to you, to looking at key documents, and to making a recommendation to you, including how much they think it's going to cost before the meter starts running. It's very important to get an attorney on board right away, to talk to them, to talk to several, to make sure that you're positioning your case as well as it can be. Very often, it will start with a letter writing campaign. And it can be an efficient way to resolve a dispute early. You have to assess preconditions to the litigation, including potential, and these are quite common, mandatory mediation provisions. But we can't stress enough that even if mediation isn't mandated, even if it's not required under the contract before you file suit, usually we suggest you do. It sometimes seems like an unnecessary factor, but if you get a mediator that adverse counsel respects, there's a decent chance that it might get resolved. Every settlement shot is worth it, because once the litigation heats up, the cost of the mediation is very small in comparison. And if you get a mediator that you love, but you know the other side isn't very fired up about, it's not very useful. If you're getting a mediator that you assume is just going to browbeat the other side but doesn't have their respect, doesn't have their trust, you almost might as well skip it. You need to get someone that both the parties will respect. And it's good to hear the weaknesses of your case from a third party in order to get the thing resolved. Also, some people don't want to bring up a settlement. They don't want to initiate settlement talks because they're concerned it looks like weakness. And it is a legitimate concern, but most attorneys are very receptive. They understand that mediation is part of the litigation process, and amongst good attorneys and ethical attorneys, it should always be a very important factor in terms of resolving these cases without going to war. I can tell you that if there's a big motion in the case, something big happening, usually it's the party that wins that motion that will initiate settlement talks, because the other side is just too hesitant when in a position of weakness to reach out, concerned that they might, and I see that we're running low on time. I do want to make a point with regard to litigating, the style of litigation, the last point. And are you litigating to litigate, to go to trial, or are you litigating to settle? And the answer is that you're always doing both. You always have to prepare for trial. Everything is preparation for trial. Every email that I send in a litigation, I anticipate either the judge or the jury or both are going to see. Usually it's just the judge. But you're writing for that. When you're entering into a dispute, or when you see a dispute on the horizon with the other side, I know there's an incentive to work it out, and that's a good incentive. That's a good instinct. But you have to realize that everything you put in writing to the other side is going to be part of that case. Any admission you make is going to be part of the case. You're writing to the jury at that point. You have to make sure that what you put in there, you will have no problem with the jury reading. So that's very important. And again, I'm going to turn it over to David because we are running low on time. Thank you, David.
I was just going to say, you guys have some case studies coming up. Let's talk about those. Those are really great and important. So if we can jump into those.
Yeah, I'm going to jump into actually my case study just very quickly, Kim, and then we'll flip back to the arbitration case study. This case study I'm talking about here is a requirements case, a requirements contract dispute. In this case, what we had was a very new distributor with a established brand, but moving into a new territory, and with a brand new team that was inexperienced in the cannabis industry. We had a cultivator who was relatively experienced, and who, as a result of the power dynamic between those two, ended up somewhat playing a hand-holding role to the distributor that was launching in this market. Even though the distributor had a solid brand, they didn't necessarily have a long-term experience in the cannabis area. In this case, the distributor was looking to do a contract as quickly as possible with as low as funds as possible, primarily due to the fact that they were still somewhat of a startup. And as a result, there was no lawyers involved in no negotiation of the contract. The key issue here that arose between the parties was ultimately the cultivator who had been helping the distributor, essentially leading the distributor by the hand in terms of how to enter into this new market, ended up not timely and fully delivering the cannabis products. The key issue that drove this was essentially a poorly set of drafted contractual provisions. And so I'll give you an example of what some of these poorly drafted contractual provisions look like. The very first one was the pricing provision. Now, upon first blush, this may not appear to be necessarily a problematic provision, and it certainly didn't between the two parties. In this case, it says, the parties hereby agree that the price per pound of cannabis flower shall be set at $2,000. The problem here is that it's stating that the price per pound of cannabis flower is $2,000, but it's not adequately defining who has the risk with regard to trim or with regard to cannabis that has been manufactured but is not actually suitable for distribution. There was a dispute over whether or not the $2,000 was for sellable marijuana or for the marijuana that was simply delivered to the distributor, of which around about 1/6 to 1/8 ended up going to waste. The next section says the purchaser shall use best efforts to prepay for all such inventory. But in the event it does not so, seller shall be entitled to recoup the invoice costs thereof off the top from the revenues collected. The problem here is twofold. The first one is best efforts. Essentially stating that the purchaser shall use best efforts to prepay is somewhat of a meaningless provision. In this case, the cultivator thought what this meant was that the distributor would be, except for exceptional circumstances, be prepaying for all of the cannabis in advance. This led to a significant breakdown in the relationship due to that misunderstanding. The second element here is prepaying for all such inventory and from the revenues collected. Based upon how this is drafted, it's putting an obligation, not necessarily a binding obligation, but it's putting an obligation for the distributor to pay for the cannabis in advance before it's handed over to the distributor and ultimately delivered to the dispensary. Of course, the problem with that is that the distributor in this case was not a licensed entity. And so as drafted, this contract actually fell afoul of local regulation and could have been viewed as an illegal contract whereby there was a trading of goods between a licensed and unlicensed entity. The same is for where it states from the revenues collected. There was no identification as to who was to collect the revenues. And it was implied, or at least pushed upon the distributor by the cultivator, that the distributor should be the one collecting the revenues from the dispensaries. And in that sort of situation, you again have a potential falling of afoul of regulations where you have an unlicensed entity collecting revenues from an actual licensed dispensary. The next provision that led to issues was the quantity provision. In this case, it was a requirements contract. So it said that the seller hereby agrees to sell all of the cannabis flower that the purchaser will require. This again led to a dispute between the parties because the term all the cannabis flower was interpreted by the cultivator to mean that this was an exclusive contract. Whereas, of course, there's no terminology here suggesting that it's an exclusive contract, but due to the fact that it says all the cannabis flower, the cultivator interpreted this to mean all of the cannabis flower needs of the distributor. And the failure to articulate whether or not this was an exclusive contract led to a subsequent dispute. Another issue was with regard to the timing of when it is orders should be made. This provision was the only provision that talked about the timing aspect of when orders would be placed, when orders would be demanded, when orders needed to be fulfilled. And the dispute that arose here was that essentially the distributor read this provision to mean that once every 30 days, they could drop an order off with the cultivator in order to be able to get somewhere between 25 pounds and 75 pounds of cannabis. Unbeknownst to the distributor, the cultivator obviously had a harvest schedule. And so while the cultivator was able to satisfy a production of 25 pounds to 75 pounds once a month, they certainly needed adequate notice in advance to be able to fulfill that contract. None of those notice provisions were included in the contract. Another example of the contract provision that led this relationship to go sour was the term of the contract. In this case, there was no termination provision. It was a set term, and the set term was stated as being no less than 24 months, which when the parties went to terminate, the cultivator essentially argued that he was due a minimum payment for 25 pounds worth of cannabis for all of the remaining months within that 24-month term. The other issue here is that the term began as of the date the last signature to the agreement was added. In this case, the parties first entered into the agreement in the beginning of the year, but the actual final signature was not added until the end of the year because it wasn't deemed material by the parties. As a result, it was not until that last signature was added that the 24-month clock began ticking. Now, in this situation, due to these contractual provisions really making the obligations and duties of the parties very unclear, there was a lack of leverage on our part. We also had a lack of money to be able to pay off the cultivator in order to be able to move on to a new cultivator. And we had a very strong need to make a very timely transition. Now, in this case, we were able to come up with a creative solution. We were able to discuss with the cultivator that there was a mutually assured destruction if they were to pursue litigation. As a relatively new upstart distributor, if they were to have pursued a large sum of money from us based upon their interpretation of the requirements contract, they weren't going to get anything because our company was going to go insolvent. Instead, we got the cultivator invested in the success of the distributor. And we essentially did that by promising to pay out the cultivator for any money that they claimed were due under the requirements contract through an earn-out provision that would be earned based upon the distributor's success with the new cultivator. Therefore, we ended up aligning the incentives of the cultivator and the distributor for the distributor to do well and successfully transition to the new cultivator. Jeff, I'll hand over to you now to talk about the case study related to the recent arbitration settlement.
Thank you, David. And I'll try and keep this moving here. And this arbitration, and I'm going to talk about issues that were public knowledge. I am certainly not going to talk about information that we gleaned during the arbitration process from the other side. But the general fact pattern is there was a licensing agreement between our client and a third-party licensor concerning the production and distribution of cannabis in the state of California. And the licensor committed fraud to obtain an early termination of the licensing agreement to avoid paying contractually obligated fees in excess of about $10 million. The essential claim was for breach of contract and for fraud. And the key issues were the hotly contested facts concerning the fraud and an arguably ambiguous contract term, which was a precondition for payment. Also, there was a lack of a mutually acceptable escape clause that could have rendered this thing a little bit easier to deal with. But it depends. Most of it depends, as with any dance. The most important thing is the partner that you pick. And sometimes you just get on the dance floor with the wrong partner, and it's going to lead to trouble. And sometimes you don't know that until you start engaging in the business. But all of these things can help, as we discussed earlier. But there was one of the key aspects of this thing was the obstructive litigation tactics that resulted in escalating fees. Evasiveness and obstruction in the discovery process is not necessarily uncommon. In fact, in my experience, it's the norm to some extent. But this was excessive. And as the arbitrator pointed out, and in our award, because of that, we were able to get a default to prevent them from further litigating the case. It's an unusually uncommon result to get that. And it resulted in the award of over $60 million in damages. But the aggressive lawyering goes in, back to the issue of how much do you invest in a case. Sometimes, and it sounds strange, but scorched earth is not always the best policy, and I want to emphasize that. Looking under every stone, deposing every witness, that's usually not the way it goes. In litigation, in litigation, it is important to pick your battles. Discuss with your lawyer the caliber of fight your company is ready to take on. This is crucial if you're going to go the distance. This case was important because we got our cannabis industry experts on board early, and it was very easy and less expensive to do because it was our clients. And I can tell you that these gentlemen forgot more about cannabis industry and regulations in the shower this morning than I will ever know. And having them work hand in hand with us, and in fact doing a lot of the legwork, contributed greatly to the result. I'm going to go into the next case study. And I apologize for the speed. We'll be available for questions both now and afterwards. But this was a David v. Goliath case, and it's actually still going on. But it is important because this fact pattern can happen a lot. And as the cannabis industry takes hold, I believe it will happen a lot more often. And the general fact pattern here is a large German automobile manufacturer poached the workforce of our client, over 40 employees, took them all in-house. The relevant contract provision precluded the manufacturer from doing exactly that during the term of the contract and for 1 year afterwards. And the German manufacturer alleged that it was vague or that it didn't mean what it said it meant. The manufacturer refused to compensate the small business owners for the poached employees. There was no liquidated damages provision, which was unfortunate to begin with, but not in light of how the case is going. The manufacturer, again, argued that our damages were too speculative. The key issue was this breach of contract. The appropriate measure of damages was always a huge issue. The manufacturer also claimed the no hire provision was vague and otherwise unenforceable under the applicable law, which in this case was New Jersey state law, which was chosen under the contract. Now, the small business had less resources, but has been contributing significant resources to pursue this because of how the other side has been litigating, not uncommon as we discussed, and the arguably vague contract terms. The important part of this case is that we brought on damages experts very early. We interviewed many of them. We made sure that we had people on board who believed in the case and who were ready to fight for it before we even filed the complaint. Again, this isn't highly unusual for litigators, but it's something for small business to consider what it can take to litigate against these big companies effectively. What happened here is the parties ended up filing competing motions for summary judgment. The defendant on various bases to throw out our case, and we filed our own motion for summary judgment affirmatively to say that there was liability and there's no need to take that issue to the jury. The court ultimately agreed with us, rejected all of their summary judgment claims, and agreed to us, which is not easy to get, to affirmative liability. And so now we're going to trial just on damages. And I can tell you that our experts are far more robust and convincing in that regard, because they were hanging their hat on the fact that they were going to get out of it entirely or that damages would be too speculative. So now we're going to trial in very good shape. And no, unfortunately, it still has not settled.
That's incredible. So we have gone a little bit long, but this is such great stuff, I've got to tell you, and really appreciate it. The questions coming in, the comments coming in, everybody wants to go a little bit longer. So we're going to go ahead and do that if you guys don't mind. But we do have a couple of really key questions. So I don't know if you want to jump into one more case study or let's do some questions. Yeah.
I'm fine. I'm fine either way, Kim.
Let's do a couple questions, and then if people want to stick around and we can maybe do one more case study, that might be a good way to wrap it up. So we talked too during some of the preview and discussion calls and things like this, cannabis is federally illegal. And so really kind of what are those options for, accessing to the courts and, getting, judgments and various things because of the fact that cannabis is still federally illegal?
Well, it's funny because us lawyers are learning this thing just like everyone else. It's an unusual situation here. I can tell you as a litigator that I'm much more comfortable being in state courts because you don't really have that illegality defense, which is very real at the federal level. I can also tell you that it's not an easy answer at the federal level. It's very nuanced. One of the ways you can protect yourself is by making sure that within your contract is a requirement that it be litigated in state courts. You can pick the venue as well, but make sure that you're going to be in state courts so that as soon as someone tries to take it to federal, you can get it kicked out. That is the most important thing. With regard to federal court, it's a nuanced argument in that if the contract is, and the provision you're trying to enforce is not directly related to cannabis, but has some legal end. And one case that discussed this was a lender who wrote a promissory note, and in the note, it said that the loan funds cannot be used for any illegal activity. And the court found that, okay, we can enforce this contract because even though it's a cannabis industry taking the loan itself was predicated upon legal business activity, and so enforced it. But I can tell you that if I was trying to enforce these contracts myself, I wouldn't want that extra layer of potential protection. But there are some special circumstances, and we know that federal cases have been filed, and very often those attorneys that pursued those cases had good reasons. But ultimately, you want to be in state court in general for a defense. You don't want the other side having a complete defense, and it will affect the settlement discussions in a way that's not good for the party trying to enforce.
The one thing I would add about the federal-state dynamic that is important to note is the lack of availability of federal bankruptcy. It's a very important thing to consider, especially in times like now, when we're seeing that a lot of the smaller entities are folding and are being absorbed. You as a cannabis company will not be able to avail of federal protections, and therefore you'll be forced into state options, which typically are assignment to the benefit of creditors or some other collaborative creditor negotiation that will require you having good faith, good relations with the creditors who are coming after you. The other big issue with that is that it doesn't just force you into these informal negotiations. You also lose a considerable amount of your bargaining power, because one of the benefits of the federal bankruptcy is that you're able to stay all litigation that is pending against you and the entity. However, without that, you can be subject, or rather your company could be subject to a host of litigations that will start to suck the funds that you have in your remaining assets, and also just become a very complicated distraction as you're trying to wind down your company.
Excellent. There's a question about SEC support for basically, support from other governing entities for publicly traded cannabis companies. We see quite a few of those in Canada, but now a lot are dual listing on OTC. So do they support claims made by shareholders in particular? Do you guys know, or is there an answer to that question?
Yeah, so in terms of supporting, I think really what you're asking is, are they pursuing claims by cannabis shareholders? And the SEC doesn't really provide a support function as much as they're an enforcement bureau. And so the question is whether or not they're bringing criminal actions. There's none that I'm aware of as of right now, and that's primarily due to the fact, as you pointed out, the vast majority of these are currently listed in Canada. Those that have decided to list in the U.S. understand the heightened regulatory scheme that's going to be operating under, and therefore tend to be a little bit more immune from these types of claims. Moving forward, would we expect that sort of criminal enforcement and civil oversight from the SEC? Absolutely. There's no reason why they wouldn't begin to consider that as any other industry, except for the fact that it's new and burgeoning, and therefore it's simply not robust enough to be a primary focus. And that is one of the key constraints with any sort of state or federal run agency is focus. And when you've got one of these newer industries, they tend to not be a lot focused, at least when it comes to certain industries, so certain government regulatory agencies. So whereas the SEC may not have its eye on cannabis, the FTC will more so have its eye on cannabis. So it really depends on the type of regulatory agency.
Okay. Do you guys want to just do one more case study and then we'll wrap it up?
Sure. I'll flip on the final case study we have. Let me just pull it on up. This is a case study related to an M&A dispute. The general fact pattern here is pretty simple to describe. There was a sale of a cannabis software company to a third party. And in exchange for that sale, the owners of the cannabis software company were granted limited upfront consideration, an initial share of shares, and a substantial cash earnout. Now, if you remember earlier on, I talked about how earnouts tend to be one of the biggest disputes that arise in M&A. That's exactly what was the cause of the issue here. Essentially, the third party ended up failing to pay the earnout. Now, typically, as I talked about previously, disputes about earnouts arise when there's a failure to align incentives with the earnout. And that's typically when new management comes in to take over the company, or there's a failure to define EBITDA, or there's a timing whereby the acquiring company ends up delaying satisfying certain hurdles such that the earnout doesn't have to be paid. None of those were issues in this particular case. In this case, the actual prior owners of the cannabis software company were retained by the new management and were leading the company and largely in charge of the operations of the company. The EBITDA and the earnout hurdles were very well defined, and they were difficult to be able to avoid by engaging any sort of bad faith operations. The issue here more so led to what I discussed earlier with regard to the protection of assets. In this case, what happened was the third party purchased the cannabis software company primarily with the goal of being able to use the assets of that cannabis software company to benefit the third party affiliate companies without any sort of revenue or compensation or consideration of any form. And as a result of hogging essentially those assets without any sort of consideration, there was no money coming in on that asset. And therefore, the company was losing out on valuable revenue streams, although on the surface, it wouldn't look as though there's any bad faith actions that are taking place. Now, a couple of litigation restraints, or the primary litigation restraint we had, is one that's also very common in M&As. The issue here was that the majority of consideration that the owners of the cannabis software company had received was a very small, limited upfront cash consideration, but a large grant of shares in the third party. Now, the problem with that is that if you've got a large equity stake in the third party, you're going to be a lot less inclined to create trouble for that third party because any impact to their shares will obviously impact the value of yours. The saving grace in this dispute was a very well-defined contract with a lot of protective provisions. And the primary protective provisions here was not simply to define what does a failure of the earnout look like. It actually included penalty provisions in the case of an earnout that allowed for self-help on the part of the owners of the cannabis software company. In this case, they were able to leverage a key protective provision that placed a pledge in the company's equity, in this case, the company's equity being the equity in the cannabis software company, that in the case of the third party improperly failed to pay out the earnout, the owners of the cannabis software company could execute that pledge and therefore reclaim the company's equity and effectively reclaim the company. The other thing they had in here as a key protective provision against bad faith on the part of the third party was cross-default provisions. And in this case, what was critical was that if there was any improper failure to pay out the earnout, that was accounted for in other agreements, side agreements that the third party entered into, specifically the employment agreements with the owners of the cannabis software company. And in that case, if the third party failed to pay the earnout, that would trigger a provision in the employment contracts with the owners of the cannabis software company and their employees, such that that would create a termination without cause, which created a substantial penalty and burden that would be automatically applied to the third party. And as a result of those protective provisions, and also the fact that we were able to adequately create a factual record that showed substantial personal representations on behalf of the principal of the third party, which we thought would lead to at least some form of liability, individual liability on their part, we were able to successfully negotiate a successful resolution to that dispute.
Fantastic. Well, we did go a little bit over, but this is, like I said, fantastic. And there are so many questions that we haven't gotten to, but we'll make sure we get those to you guys, and then anyone interested in corresponding with you maybe a little bit further about specific issues and things that they may be dealing with, we'll make sure that we share your contact information and everything else. But I just want to say, thank you so much for joining us today. Zuber is such a great partner. We really enjoy these programs together, sharing this information, and so there's going to be more to come in the future. So I just want to say thank you very much. And also thank you to everybody here for your support of Arcview. There is a poll here, and I encourage everyone to please complete this survey. It really helps us to identify those key areas that we can help unpack for you and bring you some great content and some great conversations. And so the other thing I want to also mention about Arcview, and you'll see this slide right behind your survey polling questions, is that, Arcview, we are really a integrated system now. We have companies, we have multiple companies, and we are here to help you in various ways. And that can be anything from consulting and looking at, where you're going to be, starting a new business or merging a company in cannabis, or federal readiness and getting ready for that, to Arcview Capital. So we've got our Capital Group now, which is a licensed broker-dealer. We have Arcview Ventures. So we have a lot of ways in which you can get into our Arcview ecosystem, and we encourage you to do that. We've got two more great programs I want to mention right before we wrap up here. But the first one is federal legalization. So we are getting really close to this. It actually could be a probable versus a possible. And we've got some incredible experts that are coming to this panel this week. And that is going to be on Thursday at 1 o'clock Pacific. So don't miss that one. Our next one is a town hall, and we're going to Arizona. So for those of you who want to join me, and let's go to Arizona together, that's going to be on the 4th of February at 11 o'clock in the morning Pacific time. And then the next one here that I'm really excited about is we are doing a white paper with NCIA, and we're going to be releasing that here shortly, along with a webinar to talk about that. And it's building new foundations in the cannabis industry. That's Friday, the 5th of February at 11 o'clock. There's a QR code there. If you hold your camera up to that, it will actually bring you to a link. And that link is our Arcview Access. And that is all of our programs, the calendar, and various ways in which we do this. So thanks again, everybody, and looking forward to seeing you at the next show.